Today, we're focusing on different pathways to accountability for the serious human rights violations and international crimes committed by the IRGC in Iran and abroad. And we're very lucky to be joined by a number of female experts in their respective fields. To kick off our panel discussion, I just want to highlight that today we are. Sorry. I just want to highlight that the report we're launching today explores more than 20 judicial and quasi-judicial avenues for pursuing accountability for human rights violations and international crimes committed by the IRGC, both inside and outside of Iran, focusing not only on what mechanism exists in theory, but on what can realistically be pursued given the current geographical landscape and with the political will of states as it stands today. Over the next 60 minutes, we will hear more about several of these aspects. For now, to get things started and guide us through HRA's new project, the Pastoran Documentation Project, how it came to fruition, and how that journey has led us here today to speak about accountability for IRGC-related patterns of abuse, I'm very pleased to hand over to Skylar Thompson, who is the Deputy Director at Human Rights Activists in Iran, leading leading efforts to advance justice and accountability for serious human rights violations and international law in Iran. She developed strategic, high-impact approaches to accountability, most recently focusing on mechanisms to hold members of the Islamic Revolutionary Guard Corps accountable and responsible for their involvement in international crimes. Her work promotes coordinated, cross-jurisdictional action and the use of targeted tools such as mechanism-style sanctions. So I'm going to hand it over to Skylar.
Thank you, Julie. Good morning or good afternoon, everybody. Thank you for being here. So as Julie said, we are launching a report today. Everyone, that's the reason that you're here. But I wanted to start the conversation off by introducing the project that brought this report to fruition, the Pastoran Documentation Project. I wanted to talk a little bit about what we've uncovered, how we've done it, and how this work has led us here today to talk about accountability. So Pastoran Documentation Project, we call it PDP internally, so that's how I'm going to refer to it going forward, is a long-term initiative by HRA. When I think about sitting down to start this project several years ago, it was really born out of the idea and understanding that there's a real desire to know more about this really veiled institution that carries out some of the gravest violations of human rights and international law, not only in Iran, not only in the region, but across the globe. We really sought to expose not just that it's a military and economic power, but a central actor in these abuses. But as I mentioned, one of the core challenges in holding the IRGC accountable has been this veil of secrecy surrounding the chain of command. That secrecy is, of course, intentional. It's designed to obscure responsibility and to shield decision makers from justice. At HRA, our goal in this project has been to pierce through that veil. We wanted to unveil who enables abuse and where that responsibility lies, not only at this top layer where it's sort of understood who gives orders, but we also wanted to reach down deeper and understand even down to the village level who is operating. And we have been able to do that. Today, if you go online at iranpdp.org, you can see that we've uncovered more than 80,000 units. It's not just today, it's dating back to 1979. So if you're someone that is looking into events that have occurred in the past, or if you're someone that's looking into events that are ongoing, or if you're someone that's looking into events that happened in 2022, we've looked at information that has to do with all of those eras of time. But to do this, we've pursued a quite rigorous, to be honest, research project. We've collected thousands of primary sources from inside of the country, and we've conducted supplementary interviews with individuals that have had firsthand accounts and knowledge of key events. Because there was so much information, we needed to conduct these interviews to sort of fill the gaps. We also crawled tens of thousands of archived websites, including social media accounts and institutional publications. And we built a digital infrastructure to really tie that all together and to be able to understand the scale and depth of the research that we had conducted. That is where the sort of information on on individuals and units' lives. But parallel to that, and alongside our partner, Uprights, who's here today, we analyzed 12 initial sets of incidents that are linked to the IRGC. At first glance, these incidents, they do look quite random, but they're not. They were chosen quite intentionally to really show exactly what I spoke about previously, that the activity happens in Argentina. So we looked at the EMEA bombings. They're happening in detention centers. We looked at sexual violence in detention centers, which we know is systematic and is ongoing in secret detention centers, but also across the country. We looked at crackdowns and protests in November 2019, but also in 2021 in Khuzestan. We also looked at Bloody Friday. So there's sort of an array of different events. And across these incidents, we identified serious international crimes, including torture, rape, murder, persecution, hostage taking, the recruitment and use of child soldiers, and terrorism. Of course, it's at a very limited level, but Valérie will go into a bit more of that at the end, I presume. In every case, what's unique and what stands out is that we've worked to link these perpetrators, which I spoke about in the beginning, the units and individuals in the database, the units of the individuals to the actions or incidents that we've documented. So this project makes the connections visible and accessible for others to act. I'll be really clear, it's not a courtroom. It's not there to issue judgments. It's not in and of itself an accountability tool, but it is an essential step in the chain. It provides a base, it provides names, structures, patterns, and those are prerequisites for action. So I think my hope is that with the launch of this report today, we can start a conversation. We have the information available, and we know that there are several pathways to accountability. I think that many people are aware that these pathways exist, but of course, there are barriers to action. I would love for these two things working in existence together to be able to start a conversation, not only among practitioners, but among those that are able to help practitioners take that action. What more could we be doing with the information available to us? And I'm really honored to be here on this panel speaking with all of these experts in their field to discuss what those options are. So I think I'll leave it there and hand it over to my colleagues.
Thank you, Skylar, for introducing the project and the starting reason of why we're here today. Next, I'd like to hand the floor to the Secretariat of the International Independent Fact-Finding Mission in Iran. First, a big congratulations on the recent report and finding, and of course, for the extension and expansion of the mandate by the Human Rights Council. This is definitely something to celebrate. So now I'd like to introduce Anna Katulu, who is the legal advisor at the FMI. And she's also joined today by Ida Maratirias-Nejad, and they will, the coordinator for the FFMI, and they will be discussing their recent findings related to accountability as outlined in the CRP, including those related to entities beyond the IRGC. So I'm happy to hand the floor over to them.
Okay, thank you very much, Julie, and thank you to human rights activists in Iran for organizing this session and inviting us to speak. Obviously very, very timely after the issuance of our report 3 weeks ago now, and our CRP. For those of you who don't know me, my name is Ida Maratirias-Nejad. I'm the coordinator of the fact-finding mission, and I'm joined by my colleague Anna Katulu, who is our legal advisor and who will walk you through some of our findings. But before I hand over, I just wanted to maybe just say a few words about our mandate and the focus of our mandate and on what we've prioritized, especially in the second year. So as many of you know, we have this sort of two-pronged mandate. One is to investigate the allegations of human rights violations in the context of the 2022 nationwide protests. And the second part of our mandate is to preserve that evidence for legal proceedings. So, so we have interpreted this mandate, the second part of the mandate, as directly supporting accountability efforts for in the future. So the first year of our mandate, we focused very much on investigating and sort of focusing on the crime-based evidence collection. The second year of our mandate, we focused more on trying to collect linkage evidence between the incidents and the violations and the crimes that we found in the first report, linking them to entities and persons of interest, including heads of entities. So that was very much reflected in the second report that was issued a couple of weeks ago. Maybe just one caveat as well is that while this is a human rights mandate, we have also looked at all of the situation from both an international human rights law perspective as well as an international criminal law perspective, opening up opportunities for accountability avenues in both areas. So with that, I'm going to hand over to my colleague Anna, who can walk you through some of the findings that we've made. Thank you.
Thank you very much, Ida. Thank you to colleagues for joining us today. So as Ida said, we've covered a number of entities, and now I'll go through those. But also we took a thematic focus because, of course, in the first report, the mission covered various events and various incidents, but also broader patterns. And so for the investigation on responsibility, we focused on the use of force resulting in deaths or serious injuries, detention, the judicial system in as much as it relates to our mandate, and the mandatory hijab enforcement. And within that, and within the human rights violations and the crimes committed in those 4 focus areas, we investigated the roles, structures, and responsibility of the IRGC, including the Basij, the police, the Faraja, including its special units, and the moral security police, as well as the Ministry of Intelligence, the Ministry of Interior, and the judiciary, and a number of governors in some provinces. So the focus was both on the heads of those entities as well as the staff within those entities that were involved in commissions of human rights violations, serious human rights violations, or crimes under international law. One of the things we considered was the knowledge of the crime, whether there were preventative or punitive measures, and those punitive measures or preventative measures would have included investigations, administrative punishments, or prosecutions of their subordinates in case of commission of crimes or violations. And so, for those who are looking at modes of liability, those would be the elements that are considered for superior responsibility, which we've considered to be kind of the starting point. And then obviously we looked also at other potential modes of liability, but that being the starting point, because that allowed us to look at the de jure and de facto roles and authority within those entities. In terms of findings in those 4 areas, and that might be of interest with regards to the work on RGC, but also with regards to other forces. On the use of force, the mission's findings focused on several incidents, which included the unlawful death in custody of Gina Massamini, as well as serious injuries, including blindings and deaths during protests in Tehran, Saqqez, Divandare, Mohabad, Balu, Amol, Sanandash, Bane, Javanrud, and Zaidan. What we observed is that the use of force in the context of the protests specifically usually involved several coordinated forces. And in that, it included the RGC, including the Basij, the Faraja, as I said, including its special units, as well as plainclothes agents of those forces. And while the mandatory hijab enforcement, if there was use of force, it involved the morality security police and potentially also the Faraja more broadly. So in that context, in the context of use of force, when we examined the responsibility of the leadership of the state and the entities, we looked at several indicators to establish whether there was de facto authority. So we collected and considered official statements as evidence of knowledge and awareness of the crimes committed by subordinates. But also of evidence of failing to prevent and punish those crimes. Such statements included, but are not limited to, statements by the then Minister of Interior, by the head of the Faraja Special Forces, and the governor of Kurdistan, for example. Other officials spoke about measures taken against the quote rioters, revealing the de facto authority. So that included statements by the RGC commander in Greater Tehran. Again, related to the use of force, the mission that then concluded that where officials had effective authority and control and the prerequisite knowledge, but failed to prevent and repress crimes, they bear responsibility for those events. On detention, we focused in this mandate period on detention facilities conducted or controlled by IRGC on the one hand, and the Ministry of Intelligence on the other hand. So that includes Ward 2A of Evin Prison and IRGC detention in Sakes, which the mission concluded that there are reasonable grounds to believe that the RGC chain of command, including the RGC commander-in-chief, bear responsibility for the crimes committed by their subordinates in those two detention facilities. Equally, the mission found that the Ministry of Intelligence hierarchy, including the Ministry of Intelligence hierarchy, including the Minister of Intelligence, bear responsibility for crimes of their subordinates in Ward 209 in Evin Prison. There is maybe one observation to be made that a lot of the victims and witnesses have spoken about the use of unofficial detention sites, especially in the context of the protests, where victims were subjected to torture, treatment, sexual violence, and enforced disappearance in what essentially is a lawless and unregulated space. And despite the fact that these sites were unofficial and sometimes witnesses struggled to identify their exact location, they were still able to provide us with information that connected agents that they've encountered, including plainclothes agents, to safe houses run by the RGC, to RGC bases or other types of buildings, and to RGC intelligence. And in some cases recognized also Basij members as handling them during their detention. On the judicial system, the mission documented more than 70 cases before revolutionary and criminal courts related to the mandate, so mainly protests and mandatory hijab enforcement, and particularly examined the role and responsibility of judges in the commission of crimes against humanity, of torture, persecution, and other inhumane acts in relation to a number of emblematic cases. Those emblematic cases were considered to be illustrative of the instrumental role that the judges played in the repression of the protest. And in this context of the judicial system, it's worth noting the central role that intelligence entities played. So this includes the Ministry of Intelligence, IRGC Intelligence Organization, and the Intelligence Police. The roles that they played in the interrogation and detention of defendants and in courtroom proceedings. Protests and mandatory hijab related cases were often elevated to national security cases, which then involved those entities. So the judges would rely on evidence and briefings provided by the intelligence entities, and representatives of those entities would often be present in the courtroom, and on some occasions have been seen by witnesses to speaking directly to the judges in the context of those proceedings. Lastly, the area of I'm a bit conscious of time, so maybe just I have very few more points to cover, but just to check in if it's okay to continue.
Yes, please continue.
Okay, sorry. So the last area is the mandatory hijab enforcement, which the mission found that the supreme leader was, of course, also responsible for the IRGC, the then president, the then minister of interior, the head of the judiciary, the Faraja commander-in-chief, the attorney general, and the IRGC commander of Tehran, in particular, contributed to what was found as to be a formulation of an agreed plan to use repressive measures to enforce the mandatory hijab. These measures, in some cases, involve the commission of crimes on international law. Senior figures agreed on the policy, which then they went on to convey to all organs of the state, demanding an all system action to enforce the hijab with the means and methods available. So this plan was also implemented by law enforcement and by the judiciary, etc. Maybe one last point on the mission's work on responsibility. So as has been said in the report, the mission created profiles of entities, incidents, and persons of interest. And information on persons of interest will also be contained in a confidential list, which will be submitted to the High Commissioner for the UN High Commissioner for Human Rights at the end of the mission's mandate. The mission is mandated to collect and preserve evidence, which includes collecting it and preserving it in the view of cooperation with any legal proceedings, as Ida mentioned. And so following UN practices and the mission's own terms of reference, the mission would consider requests for assistance in the context of credible accountability processes and may share evidence analysis subject to consent, confidentiality considerations, and security and risk assessment. With that, I'm handing back.
Okay, thank you for the input from the FFMI. I think we're very grateful to hear about all of the important work and information that you've accumulated over the past few years, and also the importance of bringing forward, victims of human rights abuses in Iran. I'm going to quickly hand it over to Natalia because she needs to leave soon. So just a very, very quick introduction. She's the legal officer at REDRESS, who specializes in universal jurisdiction, financial accountability, and repurposing of assets frozen under the Magnitsky sanctions. She has a much longer work background, but for now, because she has to leave soon, I'm going to hand it over to her.
Thank you so much, Julie, and thank you so much for having me here today. It's really a pleasure to be speaking to all of you. I was going to start by introducing myself, but you've kindly done this for me now. So I'll just say that for those of you who do not know REDRESS, we are an NGO based in London, The Hague, that pursues legal claims on behalf of survivors of torture, including those in Iran, to obtain justice and reparation for the violations of their human rights. As part of this work, REDRESS has represented individuals affected by arbitrary detention and state hostage-taking in Iran. This includes, for example, representing Nazanin Zaghari-Ratcliffe, a British-Iranian citizen who was arbitrarily detained and tortured in Iran from 2016 to 2022. As part of our work on her case, we submitted 2 dossiers of evidence to sanction authorities across the UK, the US, the EU, Canada, and Australia, requesting Magnitsky-style sanctions on 20 Iranian officials involved in Iran's systematic practice of state hostage-taking. A final tranche targeting 10 more perpetrators will be submitted later this year. All of these submissions were based on testimony from victims of hostage-taking in Iran, as well as arbitrary detention, overall highlighting the grave human rights violations committed by the Iranian regime, such as arbitrary arrest, torture, and violations of due process. In this work, we have been very generously supported by HIR, who provided crucial information on those behind the abuses, as well as the broader structures in Iran, including the IRGC's role in enabling the violations we were investigating. In addition, in November 2023, REDRESS, again with the support of human rights activists in Iran, published a case study on how Magnitsky-style sanctions can serve as a tool for accountability for human rights abuses in Iran. And in my presentation today, I'll be drawing on some of this work to set out what Magnitsky-style sanctions are, why they matter in the context of Iran, as well as provide some recommendations for strengthening their use in this context. Now, to begin with, a very short introduction. What are Magnitsky-style sanctions? For those of you who do not know, they are targeted measures that are imposed by countries like the US, UK, EU, Australia, and Canada on individuals and entities involved in serious human rights violations and corruption. These sanctions can be imposed on state actors as well as individuals and effectively freeze their assets, block access to financial markets, and restrict their international travel. Quite importantly, unlike broad-based countrywide or sector-wide sanctions, Magnitsky-style sanctions focus on specific perpetrators, not entire sectors, and thereby seek to reduce the harm they cause to civilian populations on a whole. With that in mind, I'm now going to proceed in the remainder of my presentation to outline 5 key advantages of Magnitsky-style sanctions and then turn to 4 areas of improvement. Now, to start with the advantages they offer as a tool for accountability. First, Magnitsky-style sanctions provide accountability by publicly naming perpetrators and damaging their international reputation. This serves both as punishment as well as a symbolic acknowledgement of victim suffering. Survivors in Iran that were interviewed by human rights activists in Iran have described the sanctions as a glimmer of hope, validating their experiences and showing international action. For example, a mother of a student that went missing after the 2022 protest that was interviewed by human rights activists in Iran shared, "Every time such a sanction is imposed, I feel like my child's disappearance isn't forgotten." In addition, survivors of hostage-taking in Iran that REDRESS has worked with have expressed strong support for targeted sanction, seeing them as one of the few tools for meaningful action available in the abuses that they have suffered. For them, Magnitsky-style sanctions targeting perpetrators help debunk Iran's claims that the victims were security agents, protecting them from victim blaming and the no smoke without fire narrative. Now, this leads me to the second advantage they may offer. By targeting the financial interests of perpetrators, Magnitsky-style sanctions undermine their ability to profit from human rights abuses, and so, in theory, disincentivize them from continuing their involvement in serious violations. Anecdotal evidence we collected suggests sanctions may have deterred Iranian authorities halting or reconsidering their role in abuses. For example, a former detainee released after the Iran's supreme leader ordered an amnesty in 2023 shared that the guards' behavior changed after sanctions were announced, even influencing prison conditions and helping secure better conditions for prisoners. Now, of course, other factors will have played a role in this situation, but this example does show the deterrent effect sanctions can potentially have. Thirdly, and briefly, Magnitsky-style sanction can also target the financial entities that sustain oppressive regimes by designating foreign companies and state-owned enterprises. In doing so, they cut off the economic resources that enable human rights abuses and expose the true nature of these entities to the Iranian public, further weakening the regime's legitimacy. Fourthly, in Iran, where human rights abuses are endorsed by the state and domestic accountability is non-existent, Magnitsky-style sanction can serve as an international recognition to victims. They acknowledge violations where Iran's justice system fails and can offer a record of abuses, supporting victims and preventing perpetrators from hiding their abuses. The US designations following Mahsa Amini's death were groundbreaking examples of this approach, as they were the first to publicly acknowledge and recognize violations committed against a single female victim, Mahsa Amini. Now, lastly, before I move to areas of improvement, Magnitsky-style sanctions also offer a vital opportunity for survivors and civil society to document abuses and pressure governments into action. Most Magnitsky-style sanction regimes offer civil society the opportunity to submit evidence directly to sanctioning governments, allowing them to participate in the justice process and shape the narrative around abuses. Even in contexts that are challenging to convince governments to impose sanctions, these submissions may serve as part of a broader advocacy strategy, raising awareness and demanding action. For example, our work with the Free Nazanin campaign provided key information to the UN fact-finding mission on Iran and informed the UN Special Rapporteur's report on state-level hostage-taking. It also led to calls from the Australian and UK Foreign Affairs Committee for their governments to explain why sanctions hadn't been imposed in relation to the violations we identified. Therefore, in this context, the request for sanctions not only can hold perpetrators accountable, but also empower civil society to influence justice processes, raise awareness, and drive government action. Now, before I move into shortcomings, I'd like to flag that Magnitsky-style sanctions have actually been underused to date in relation to Iran. While support for sanctions more generally against Iran is strong, current international designations by the US, the UK, EU, Canada, and Australia have often focused more on counterterrorism or nuclear deterrence purposes, seeking to address those who are claimed to be destabilizing regional relations, rather than those who have been perpetrating human rights violations. Although many of the individuals targeted for destabilization, these individuals have also been found to be complicit in domestic human rights abuses, but this has not been necessarily reflected in the designation statement. Now, all of this is not to say that Magnitsky-style sanctions are a cure-all or that their application is without flaws. Quite far from it. There are significant shortcomings, and by way of conclusion, I'll address a few ways of how we can mitigate those. First, for Magnitsky-style sanctions to be as effective as possible, they need to be imposed in coordination with international partners. Such coordinated action is particularly crucial to prevent sanctions individuals from exploiting loopholes. Only a unified approach sends a strong message that impunity for human rights violations in Iran will not be tolerated. Second, these designations must be based on solid evidence from survivors. This process must be transparent with clear justifications for each designation while engaging civil society organizations to enhance their effectiveness. What this effectively means is that government need to effectively collaborate with civil society organizations, take the evidence seriously, and ask for their feedback on designations. Civil society organizations often possess critical insights into the broader context of abuses and the networks of perpetrators. This can help make targeted sanctions more legitimate and more effective in deterring human rights violations. Third, of course, sanctions must be applied fairly and impartially. This is especially crucial in the context of Iran, where concerns about Western double standards persist, meaning that any future designation must consistently be grounded in human rights consideration and be informed by survivors' experiences. These designations must also be accompanied by clear statements acknowledging officials' role in human rights violations, thereby creating a future record for accountability purpose. Finally, broader sanctions against Iran that are already in place must be regularly reviewed to ensure that they do not harm civilians. Without such reviews, Magnitsky-style sanctions, even when imposed, risk being part of a broader sanction regime that may be perceived unjust by local populations. This must be coupled by efforts of diplomatic missions in Geneva and New York to align their condemnations of Iran's widespread human rights violations with concrete actions at the national level. Now, I'll conclude by saying that when Magnitsky-style sanctions are used of a broader strategy, they can be a vital tool in holding Iran's regime accountable for human rights violations. And I think the impact they can have is best summarized in the statement that human rights activist for Iran obtained, who recently interviewed a political prisoner. He said, "It is a ray of hope for people like me who suffer under their reign. It may not change things overnight, but it shows us that the world hasn't turned a blind eye. Now, again, the statement aptly summarizes the accountability function sanction can serve, documenting human rights violations and acknowledging victim suffering. With that, I conclude my remarks, and yeah, thank you very much for your time.
Thank you, Natalia, for sharing your insights on the importance of Magnitsky-style sanctions. I'm going to hand it over now to our final speaker, which is Valérie Gabard, co-director of Uprights and HRA's partner in the launch of today's report. Valérie has over a decade of experience as a legal advisor to the United Nations in international criminal law, humanitarian law, human rights law, and transitional justice. Before co-founding Upright, she also served on the UN International Commission of Inquiry for Mali and the team of international experts on the situation in Kasai, DRC, where she investigated international crimes and gross human rights violations. She previously worked as a legal officer at the ICTY and Rwanda, and at the extraordinary chambers in the courts of Cambodia. Today, Valérie will be discussing the feasibility, strengths, and limitation of various judicial and non-judicial pathways as outlined in the report. So I'm going to hand it over to Valérie.
Thank you, Julie, and good afternoon, everyone, or good morning, depending on your time zone. I'm really happy to be here side by side with human rights activists in Iran. Strong partner. We fit very well the mandate of Upright as an NGO, which mandate is to work in partnerships to advance international law. So that fit very well. Thanks for the very personal presentation, Julie. But also, I'd like to say that this is teamwork within Upright, and not only my work. So I would like to thank my colleagues, even though I'm the public face today, and in particular my colleague V, who is here in the audience. We've went from specific to now. Maybe we will go a little bit more in general and discussing a little bit more what you can find in the guide that HRA is publishing today. So in fact, the two presentations that we just heard on the fact-finding missions and on the Magnitsky-style sanctions are both two types of accountability pathway that you will find discussed in the guide. But now maybe I'll try to use this opportunity to give a little bit of a broader overview. The primary goal of the guide that we published today is to empower and support a broader audience of victims, human rights activists, civil society, and in fact, any stakeholder interested in accountability in relation to the IRGC in Iran. It provides an overview of the existing judicial, but also non-judicial pathway for pursuing accountability for serious human rights violation and international crimes. What we try to achieve here is not a very technical document, but rather a guide designed to be accessible and ensuring that the audience can gain practical insights in order to better understand expectations from those pathways, as well as assisting with strategizing accountability efforts. Now, I'm not going to lie, pursuing accountability for IRGC's conduct in Iran or outside of Iran is a challenge and not a small one. The first reason why accountability is a challenge in the context of Iran is the lack of domestic avenue, which was noted by the special rapporteur and also by the fact-finding missions in several instances. In reality, Iran bears the primary responsibility to address allegations of human rights violations committed in Iran or by IRGC members, but pursuing accountability in Iran right now is just not a viable option. I will not go into all the challenges, but the lack of judicial independence, the discriminatory legal framework are all instances that led to quasi-impunity for IRGC members in Iran. So while acknowledging this limitation within Iran, the guide proposed other pathways with a focus on victim-centered processes. There are judicial, quasi-judicial, and non-judicial pathways outside of Iran that can and should be pursued to promote justice for victims. Each of the pathways discussed in the guides have limitations and specific requirements that are clearly set out. And we also look into their feasibility or lack thereof under the present circumstances. It's not possible to present all the pathways that the guide explores. So I've just chosen here to briefly explore some judicial pathway to illustrate the approach chosen by the guide and on what you'll be able to find in more details in the guide. So judicial pathways include national courts outside of Iran, the International Court of Justice, ICJ, I will refer to it, and the International Criminal Court, ICC. Judicial pathways are generally difficult to pursue, but in certain instances, they provide concrete and realizable outcomes. A finding by domestic or international courts is likely to be binding legal decisions, so like a very strong outcome. In contrast, recommendation by non-judicial pathways such as UN human rights body or truth-seeking initiative may be more accessible, but not likely to be as binding or strong. But even within the judicial pathway, challenge and feasibility can vary considerably. For instance, judicial pathways at the national level, outside of Iran, just to be clear, despite their complexity and challenges, appears to have a higher likelihood of success than international ones, like the ICJ and the ICC, for instance. So just to go a little bit into details into that, just to make it a little bit more concrete, one of the IRGC classic modus operandi is to commit violation and crimes targeting dissidents to the Iranian regime all over the world. That is very specific modus operandi of the IRGC that we've seen over the year all over the world. Obviously, states where this act takes place hold natural jurisdiction to investigate and prosecute those crimes under their own domestic law. This is classic territorial jurisdictions. And over the years, several countries prosecuted individuals connected to the IRGC for crimes committed in their own territory. One of the most emblematic cases is the 1994 MEA bombing in Buenos Aires, Argentina, for which Argentina highest criminal courts concluded that the Hezbollah, under IRGC direction and financings, was responsible for the bombing that resulted in 85 deaths and 300 injured. Now, what about violations and crimes allegedly committed by the IRGC in Iran against Iranian citizens? Can they be prosecuted by other national courts? The short answer is yes, relying on extraterritorial jurisdictions and in particular universal jurisdictions. Universal jurisdictions recognize that some crimes are so grave that they concern the international community as a whole, can name torture, crimes against humanity, and that they allow states to investigate and prosecute individuals regardless of where the crimes occurred and regardless of the nationalities involved. However, applying universal jurisdictions isn't automatic, as it depends on each country's domestic law. Moreover, it often requires the presence of the accused within the country in questions. And even when all the legal thresholds are met, there is a lot of political challenges, prosecutorial discretion that can act as barrier, for instance. So that being said, in 2022, Sweden convicted Iranian official Haim Nouri for war crimes tied into the 1988 prison massacre in Iran, sentencing him to life prisons. Although later returned to Iran in a classic prisoner swap, the case remained a landmark for universal jurisdictions in relation to Iran. And there's another case that is under investigations in the UK, open in 2024. Even though those cases do not concern directly IRGC members, they concern Iranian officials And they show that accountability for crimes committed in Iran can be pursued through universal jurisdictions. Always bearing in mind that this pathway will be complex and challenging. So for victims, civil society, the path of universal jurisdictions will be long, costly, and uncertain. And while successful conviction exists, they can often take years to materialize. So that's just to show you the type of information that you will be able to find in the guides in relation of trying to assess whether universal jurisdiction is a pathway to consider given the particular incidents that you are looking at. The pursuit of accountability through international judicial pathways, such as the ICC or the International Court of Justice, are less feasible, as it faces significant challenges in the context of Iran, primarily due to Iran's limited engagements with international human rights law in general. So, for instance, if we take the ICC, Iran is not a state party to the ICC. As a result, the ICC doesn't have jurisdictions over international crimes committed in Iran by its national, such as IRGC member. Unless Iran would consent to the jurisdiction of the court, or the Security Council would refer the situation of Iran to the ICC, which are both politically improbable, there is no way the ICC could exercise its jurisdiction over Iran. As a result, if we think of recent events such as the brutal repression of the women life freedom protests, they cannot fall under the jurisdiction of the ICC, even though they could qualify as crimes against humanity, as it was recognized by the fact-finding mission, for instance, in their last report. So civil society could try to submit Article 15 communication to try to convince the ICC prosecutor of the jurisdiction for maybe crimes committed by Iranian national on the territory outside of Iran, on the territory of other states party, or use them as a way to raise awareness about the gravity of the crimes committed in Iran. But in the current circumstances, the prospect of the ICC opening an investigation in relation to Iran or IRGC member is highly unlikely. Just for the sake of briefness, because I would like to leave some time for debate, the same holds true for the International Court of Justice. I'm not going to go into a lot of details, but given the low level of ratification of international human rights treaties by Iran, the accountability pathway available in relation to the International Court of Justice are really limited. So maybe one or two ways to consider, but there would be very challenges, and I will leave it to you to look at it in the guide in more detail. Just to conclude, while I mostly mentioned some judicial pathway here to give you a little bit of a test of what you can find in the guide, it's only one piece of a broader puzzle. This guide takes a broad view on accountability and accountability pathway and address other quasi-judicial, non-judicial pathway, notably also deal with questions related to transitional justice, such as truth-seeking, reparations, and victim support, which are crucial to address accountability in Iran, given the few accountability pathway available. So obstacles to obtaining justice in relation to Iran are high. And if we want to take that path, we should not be naive about the obstacles and challenges, otherwise we risk to be discouraged or disappointed. It doesn't mean that we, as a community fighting for victims and justice, should not do it, but we should just plainly be aware of what to expect. So as we launch this guide, we call on all the stakeholders to use and even abuse it as a strategic and practical tool to empower victims and effectively challenge impunity. Thank
you so much, Valérie, for sharing the judicial and non-judicial pathways to accountability. Due to slight time constraint, I think we might only have time for 1 or 2 questions. So if anybody does have any questions, please feel free to drop them in the Q&A box. But before we get to that, I would like to thank all of the panelists for being here today and for sharing their very powerful contributions with us.